Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
Learned senior advocate appearing on behalf of the pro forma respondent who was also claiming some right, title and interest in the property in question has supported the appellant. Stop. Having heard the learned senior advocates appearing on behalf of the respective parties and having gone through the impugned order passed by the High Court determining the monthly compensation at the rate rupees 2,50,000, we are of the opinion that the approach adopted by the High Court is not a sound principle of law to form the basis for determining the compensation in this case. Stop. In the present case, while determining the monthly compensation, the High Court has considered the fair rate of return at the rate 6.5% annually on the amount for which the appellant purchased the property in the year 2008, that is rupees 5.50 crores. Stop. The aforesaid could not have been the basis while determining the monthly compensation. Stop. If the approach adopted by the High Court is accepted and or approved in a given case, it may happen that the lessor might have purchased the property 40 years back and or long back, and if the said approach is considered and thereafter the monthly compensation is determined, the same cannot be said to be a reasonable compensation. Stop. The aforesaid would be contrary to the law laid down by this court in the case of Atma Ram Properties Limited Supra and further reiterated by this court in the case of Supermax International Private Limited and others, as observed and held by this court in the case of Atma Ram Properties Limited Supra. From the date of the decree of eviction, the tenant is liable to pay mason profits or compensation for use and occupation of the premises at the same rate at which the landlord would have been able to let out the premises and earn rent if the tenant would have vacated the premises. Stop. The landlord is not bound by the contractual rate of rent effective for the period preceding the date of the decree. Stop. The decision in the case of Atma Ram Properties Limited has been subsequently followed by this court in the case of Supermax International Private Limited and others Supra. Stop. In the said decision, it is further observed that and held that in fixing the amount subject to payment of which the execution of the order decree is stayed, the court would exercise restraint and would not fix any excessive, fanciful or punitive amount. Stop. Therefore, in a revision appeal preferred by the tenant who has suffered an eviction decree, the appellate revisional court, while staying the eviction decree, can direct the tenant to pay the compensation for use and occupation of the tenancy premises upon the contractual rate of rent, and such compensation for use and occupation of the premises would be at the same rate at which the landlord would have been able to let out the premises and earn rent if the tenant would. In the present case, the High Court has not done that exercise and has determined. Stop.